know when we're going live. The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, and welcome to this special Zoom sitting of the Appeals Court. I'm Judge Milkey. With me is Judge Blake and Judge Sachs, and together we are your panel on this case. The case being Leah versus Trustee of the City Center Office Condominium Trust et al. 2022 P886. We will hear first from the appellant.
May I proceed, Your Honor?
Yes.
Good morning, Justices. My name is Attorney David Krumsick, and I am counsel to the appellant, Dr. MANHUI Liu. She is the owner of a commercial condominium known as Unit.
Counsel, I just want to jump in on two things. One is we have read the briefs. We're familiar with both the facts and the arguments. Could we also just do a housekeeping matter first?
Sure.
The rules require that the judgment be in the record appendix. From what we can find, it is not there. Also, there is the operative complaint, or any complaint is not there, and no answer. Now, the complaint and the answers are not specifically required by the rules, but it is typical practice to have them in the record appendix. We would like to get copies of all those documents, as well as one small subset of some other documents I will go over in a second. So just to be clear, the judgment, the operative complaint, which is, as I understand it, is either called the second amended complaint or the third amended complaint. My understanding is the fourth amended complaint was never allowed. And the answer and any affirmative defenses or counterclaims filed, at least by mystery. And in terms of other documents, there appears to be one of the 2007 proposed amendments to the master deed in the record, but maybe I looked too quickly, but I don't see the other 2007 amendment, nor do I see the 2004 amendment. And if you could provide those by close of business on, let's say, Thursday. Is that doable?
Certainly, Justice. Is there a way you want me to get it to, or should I just email it to them?
Electronic would be fine with me.
Okay.
And seeing head shakes from my colleagues, that's. Now,
Okay.
can I say your argument here is, tell me if I'm wrong, a relatively simple one. You're saying that the deed says, references the original master deed and the floor plan. You claim there's no ambiguity in that. End of story. Is that a fair summary?
Yes, Judge. I mean, I think that this is I feel like the errors have been kind of flipped here. The errors are those of the attorney that represented the seller of the property.
But tell me if I'm wrong. You do not appear to be arguing that your client, in fact, again, as a matter of fact, relied on the original floor plans and thought she was getting something different from what anyone inside Unit 204 would have seen at the time.
Well, that's a little bit of a tricky question, because she thought she was getting 1,569 square feet of commercial space. That's the issue that's the most important to my client.
Okay, but it seems undisputed that her own contractor, who went in to fit out the place, discovered that it was 200 square feet smaller.
Correct.
And we know the attorney, her attorney, became aware of the discrepancy as well. And the unit deed itself was modified in terms of the percentage of the common area involved. So it went from, I think it was 6.8 and change to 5.6. Why doesn't that, for example, create either solid evidence of what she knew and or ambiguity in the deed?
Well, I'm going to answer the last part of it first. The condominium beneficial interest is not does not correlate with the square footage of any of the units. It's a mix of value of the property. For example, a 2,000 square foot property at the top of a penthouse is worth more than a 2,000 basement unit. So it's not exactly correlating. As a matter of fact, it's made clear in a prior amendment, which is covered in the fact section of my brief, that deal with that an amendment was made to change it so that it was not the percentage interest was not tied into the square footage. So that's that issue. And in terms of the square footage that my client thought she was getting, is that the deed that she received, that she recorded, that she paid full price for, that she was marketed to her as 1,569 square feet, identifies a unit in a condominium that in turn identifies by description a floor plan, which designates or ascribes to unit 204 at 1,569 square feet.
Okay, understood, but her contractor discovered this. Her attorney discovered this.
Right.
Why shouldn't that knowledge be imputed to her?
Well, for example, let me use an example involving land. If you bought an acre of land and you saw there was a fence at the back of the property, and your contractor walked the property and realized that the fence was on your property you were buying, and that the neighbor had put it up, and it cut off 16% of the back of your lot, yet you still got lot one on a recorded plan, and lot one shows that the square footage of that lot was 1 acre. And if you later went in and said, hey, I want the neighbor to move that fence, and the judge said, too bad, you were aware that that fence was there, and you were aware that cut off 16% of your property, you're out of luck. That's exactly what we have here.
Can I just stop you? Is it because the wall is the wall, and anyone inside that apartment, as we know she was before she bought the property, would have seen a very different wall than was shown on the master deed plans. It takes lots of jogs. It's not the straight line. And we're talking about an interior wall as opposed to, a fence out in the open. I mean, at least in other contexts, the buyer of property is charged with knowing the conditions that are obvious on the ground when he or she purchases. Why shouldn't we rely on that principle here?
Well, what we're talking about is an encroaching wall. She was aware of the encroaching wall, and certainly if for adverse possession purposes, she was going to be aware of that if that clock had run, but it didn't in this circumstance. And by the way, the wall was put in by a tenant, not an owner, not the seller. It was put in by a tenant of the seller. That's referenced in the described in the fact section of my brief. So it really was the tenant had put the wall in the wrong place. That's the only thing that really changed the equation here. Because
is there anything in the record that explains what triggered the dispute entering into the lawsuit? Because a lot of years went by.
Yeah, because Dr. Liu realized on her tax bill that her tax bill indicated she had 1,569 square feet, which is the square footage ascribed to her unit by the condominium association, by the condominium documents, I should say. So that's what triggered, that put her on inquiry, and that led to, further examination. And then she found out that the units were designated in such a fashion that the walls encroached significantly on the unit that she purchased.
Yeah, I don't think you actually answered my question of whether or not the knowledge of her contractor and her lawyer should be imputed to her.
It should be, to answer your question, because it should be imputed to her, because it's inescapable that that was her attorney. I've looked at the law that the judge cited in his decision. It's correct. She's stuck with it, whether she actually knew or didn't know. It's imputed to her because her lawyer knew.
Why doesn't that answer the question? If
Because
she was aware of the discrepancy between the deed and what the as-built conditions, and she knew there was a plan to amend the underlying papers to conform to the as-built, why doesn't that answer the case?
Well, I think that it doesn't answer the case because we have a contract here. The purchase and sale agreement covers in two significant sections the issues that are at play here. The first section is paragraph 28 of the purchase and sale agreement, which states that it's a common integration clause. This instrument sets forth the entire contract between the parties and may be canceled, modified, or amended only by written instrument executed by both the seller and the buyer. So what you have here is that the lawyers, when Dr. Liu's lawyer, who she hired to examine title, looked it up and found it, and realized there was an issue with the physical layout versus the described layout in the condominium plans. She worked with the other attorney without discussing anything with my client, and my client stuck with that, but worked with the other attorney to come up with its plan to modify it and modify and amend the not only the condominium documents, but the purchase and sale agreement. And that can only be done by a signed agreement by the parties, clearly set forth in the contract.
We know they modified the P&S to the extent of reducing the percentage of the common space that went commensurate with this unit, right?
No, you mean by agreement? You mean the lawyers working together to put together the amendments? So you mean?
I'm saying that the deed says 5.6% and the P&S says 6.8 and change. And now I before you said, oh, but that's calculated by a number of things. It's not a straight line with the square footage, but it was modified.
Well, it can only be modified by a formal process set forth in the condominium.
What's in the deed?
That was never done.
We don't have either of the amendments to the P&S either. I know the judge said one of them was immaterial. The other one may have just been a postponing of the closing date. But if you could get those amendments to us, it's very helpful to have all of the documents that.
Right. I don't, to be honest with you, I came in as a successor counsel, so I don't know if I have those documents. I'll try and find them.
But I'd like to ask another question. There was a 2004 master deed amendment that purported to change the unit names, swapping 201 for 204, and then purported to alter the percentage of the interest in the common areas and facilities. But the judge said that at least the effort to change the percentage interest in the common areas was ineffective because the 2004 master deed amendment wasn't signed by all of the unit owners. Am I correct so far?
Yes.
Why would the 2004 amendment even be effective to change the unit names where it wasn't signed by all unit owners? And if that's true, then when your client accepted the deed that said unit 204, why isn't that accepting 204 as shown in the plans originally recorded with the master deed? which is in
I
other
don't,
words.
yeah, I see a question. That was not an issue that we chased because it wasn't really in dispute. Judge Val Ray concluded that the changing of the designations was effective. I don't know if it was the same instrument.
Why is it? Yes, well, it was supposedly the 2004 Master Deed Amendment, and is it Master Deed 17A Romanet 3 says no instrument of amendment which alters the percentage of the undivided interest shall be of any force or effect unless the same has been signed by all unit owners. So why should it, if it's ineffective to change the percentage interest because it wasn't signed by all unit owners, why is it effective to change the unit designations?
I don't know. The deed that the purchase and sale agreement and the deed that was conveyed to my client not only referenced the unit designation, but also referenced the deeds that Breton LLC, which is my client's seller, obtained. So the chain of title is the same. So you get there the same way. I think what you're focusing on, Your Honor, if I can be presumptive, is you're trying to make sure that the P&S and the deed reference the proper unit that we're talking about.
Well, the P&S was more specific in the units that it referenced. It referred to Unit 204, formerly known as Unit 201, but did the actual deed. And if we have a conflict between the P&S and the deed, what controls?
Conflict between the P&S and the deed. I would think the deed controls.
I did have one other question, and I'm sure the other panelists have questions. You argue in your brief that there was a third option that the judge didn't consider, which was to accept such title as the seller was able to deliver.
Right. Yes.
Where did you argue that to the judge?
When did I argue that?
When or where in the record can we see that you preserved that argument?
There would have been an oral argument at the trial. I was involved in the second trial, not the first trial.
And we don't have transcripts, right?
No.
Part of your argument is this doesn't fit as a waiver case. A more natural fit is as a reformation case, based, for example, on mutual mistake, or a unilateral mistake that your client was aware of. What are we supposed to do if we were to conclude that this is really a reformation case?
Well, I think the reformation which would be needed is to reform there still needs to be some work done to change the beneficial interest in the trust as opposed to the square footage of the units. My position is that the square footage of the units is in the layout is as set forth in the floor plans, which are the only floor plans which have been recorded at the registry.
Well, I mean, given that we can affirm on any grounds fairly supported by the record, were we to determine that this is a textbook reformation case, can we simply affirm on that ground?
I don't know. I don't know if you can. I hadn't. I think that's the appellee's argument if they advanced one, but they didn't.
Well, we can affirm on any ground, regardless of what the appellee argues on appeal.
I'm not sure, Your Honor.
Do either of my colleagues have any follow-up questions? Hearing none, we will see if we have questions of appellee counsel. Let me just ask, you heard me mention reformation is potentially a better fit. Did reformation ever come up in this case?
In the very first day, Your Honor, it did come up when the case, when we were in the process of, let me think about this, answering the complaint, I believe. And then when we had an argument at one of the status hearings, that was the very first thing that was suggested by Mystery is, look, there's been some papers that haven't been executed properly. We can confirm those, such as a special amendment. I think they needed to confirm that in terms of a signature. And then there were also some amendments that they could correct with the correct condominium percentage, Your Honor. So yes, that did come up.
Was it ever formally pled by you in terms of either an affirmative defense or a counterclaim?
Yes, it was, Your Honor. In fact, this might be getting off a little bit, but my client's deed had some errors in it. So we also did a confirmatory deed, but we did not record that deed while the case was pending. But yes, that did come up.
And I noticed that this is not particularly clear in the brief, but appears that a settlement was reached between the trustees and the plaintiff. I take it the trustees are satisfied that what had to be done here was done in terms of their interests?
I believe so, Your Honor. We needed to rewrite some of the amendments, or mystery was ordered to do that, but then the trustees took over that task to make any corrections. And I know that there was some settlement, although we are not privy to that settlement. I don't know if there was money involved or if it was just correcting the amendments, but to my knowledge, yes, they are satisfied.
Okay, just want to stay on the fly. We are actually, I think it's probably prudent, given that we're asking for a number of documents here, to put an order in writing. So sometime today, we will actually formalize our request for the additional documents from the plaintiff. Do my colleagues have any further questions of mystery? Love the name. Okay, well, that concludes this hearing. Again, we will issue an order clarifying which documents we're looking for. And that concludes this Zoom hearing. The case is submitted.
Thank
Thank
you.